So thank you everyone for being with us today, online and in the room. Maybe just before we start, the idea, so our practice, we represent in our firm international civil servants in different contexts. And there is a current context that is quite unique, at least based on what we've seen before. And the idea with the meeting today was to go over some of the situations, or going back to the main principles that are applicable to international civil servants, and then go over some of the situations that we have identified in this particular context, and give some tools on how to react, what can be done. Obviously, there are some limitations. We are supporting the organizations in the effort of keeping a strong multilateralism. However, we believe that it's interesting for international civil servants to know their rights and to know what can be done. We don't have all the answers to all these situations, so we cannot provide legal advice on all the situations within the context of this particular event, but we identified some of the key issues, and we hope that it will be helpful for you, and we are also welcoming the questions at the end of the presentation. So we have a presentation in two main parts. The first one will be about the main principles applicable to the labor law of civil servants, what can be expected, and at which stage, what are the different stages. And then we also, because we're based in Geneva, a lot of the questions that we receive are on the impact on immigration status in particular. So we thought that it would be interesting also to have a second part that is more specific to Switzerland on what can be done also to stay, or what can be expected for the future if someone, for instance, knows that there would be a termination of employment in an international organization. Let's start with the first part. Without the situation is different for each of the organizations, but what we know is that the general situation is such that there are some funding cuts, that there are some delays in payments for the international organizations, that there is a reflection on how to prioritize the core mandates of each of the organizations, and there are some geopolitical tensions that have the impact of having some of the states focusing on bilateralism versus multilateralism. So this is the situation, and the numbers are difficult to find, and they change also. So I'm not. The purpose of the presentation is not to be necessarily 100% accurate on the numbers themselves, but based on the main sources of information that we found. There are clearly some budget cuts in different organizations, including organizations that have their HQ based in Geneva. And we can anticipate that there would be some job loss at local level, but also at global level. So here are some of the figures that have been able to retrieve. But again, this changes more or less every day, and it depends on the organizations. But I thought that it would be helpful to have a sort of a big picture on what can be expected.
Can I just quickly ask, UN, this is in Geneva, or UN all over the world? Global.
But again, I didn't go into the minutes of each of the documents, the official documents of the organizations. But this is what we can see in the press, at least in this past weeks. And we also wanted to emphasize the fact that job cuts are not the only impact. You would have obviously job loss, so non-renewal, termination, early retirements, for instance. This is probably something that we can anticipate, but there are also changes in the missions. So some of the positions, they will remain, but they will be drastically different, which also has an impact on the employment situation of the person. We can also anticipate that some of the employees will be facing relocation, voluntary or less voluntary. So because there is also a trend for a more regional approach. So we can see that in the discussions There are some important discussions on having some of the positions being relocated more regionally. There is also an impact in terms of career perspectives. Am I going to be able to get a job at the higher grade at some point? Am I going to be able to have more responsibilities? Is there, I don't know, a P5 position for me in 5 or 10 years that I can anticipate? And this overall context creates also a situation where there is an increase in the psychological risks. Well-being at work is definitely an issue that there will be some impacts in terms of well-being at work. Not just because of the job loss, but also because of the reorganization. It's natural in any work environment, and when there is such a reorganization at such a large scale, that it will have an impact on how everyone feels at work. And that could also have an impact on interpersonal relations, misconducts, harassment, etc., etc. So with that picture, what can be done? And this is really what we wanted to provide today. What are the tools? What can I do if this is something that I can see in my situation? First, our first advice is know your rights. Try to look at the information that is available. These are basic points, but just as a reminder, first, there are some staff rules and regulations that are unique to each organization. So each organization has staff rules and regulations. You'll find some common principles that are the same in all the organizations, but still look at the staff rules and regulations if you have questions. There are some organization-specific rules and guidelines. Sometimes they're not very easily accessible online, so you might want to retrieve this information in the intranet, or you can also contact HR if you have questions on how to get this information. There are some specific rules regarding early retirement. Am I within the age range that allows me to seek early retirement? Looking at this room, I'm not sure whether you're really concerned by that particular question, but this is something that is also important for a large number of international civil servants today. And then, important source of information is the case law of the International Administrative Tribunals, but they're not necessarily easy to retrieve, but this is also a resource. And there are some associations, staff unions within the organizations that are very important to obtain information on the specific situation of a specific organization. So, first advice, try to identify what are your rights in a specific situation. Also, how does it work? What I see in my practice is that often we don't start with a litigation, obviously. We start with a negotiation. So, I just wrote asking is for free because I think this is always a good first step. Like, is it possible to engage in a discussion? Is it possible to have a negotiation on the situation? And then this is common to all international organizations, but there is always first an internal procedure. You can ask for reconsideration of such decision. For instance, if there is a decision to terminate the contract, the first step would be to ask potentially for reconsideration. Then there is an appeal process that is usually internal to the organization. And then that's where I go back to my previous point on the fact that this context will create tensions, and you may have an increase in situations of misconduct, of harassment, etc., etc. And so there are also some other mechanisms that are specific to these situations. So you would have the possibility to file an internal complaint, you would have the possibility to seek the support of an ombudsperson, etc., etc. So it's important to know that these avenues exist. And then again, like if the internal procedures don't work, there is a possibility to engage in litigations before external tribunals. And then depending on which organization you work in, the one tribunal or another would have jurisdiction over the matter. So so basically it's either the UN Dispute Tribunal and the UN Appeals Tribunal or the ILO Administrative Tribunal. So to be more specific on what can be done if a situation arises. What we've seen in the previous month is that one question first is, how do I increase my level of protection? I think that we all know that there are different types of contracts within the international organizations, and that some of these contracts are very precarious. So you might want to see whether there is something that can be done in terms of increasing your level of protection. For instance, we have had cases where we had clients who had been on special short-term contracts for many years, which had an impact on the fact that they wouldn't be able to seek some of the social benefits or for the pension fund, etc., etc. So our first step when we look at these cases is, could we start an argument on the fact that you're not under the correct contract? And I invite you all, independently on whether or not you know that your contract will be terminated, to have that perspective in mind, because especially in this context when you don't know what will happen in the coming month, you cannot rely on the fact that your contract, even though it has been reconducted for many years, will be indeed reconducted this year. So I think that that's one important point to verify first. Then you might want to do the same thing in terms of grades and steps, like do I fall under a situation where I could be asking for requalification, etc., etc. But what we see is it's more about the types of contract. Grades and steps are going to make a difference in terms of wages, but the type of contract will make a big difference in terms of social protection and benefits. If someone gets a letter that says, okay, your contract will be terminated, or we will not renew your contract, there is then it's the time to think about whether or not there is a possibility to challenge that termination. The termination in itself, it's important to understand that if there is a need for the organization to reorganize, then the statutes usually will provide for the possibility for the organization to terminate some of the contracts. But there is a framework in each of the statutes, and this framework will be that usually there is a right for an indemnity for the termination, usually there is a notice period. So it's important to keep that in mind if someone receives a letter of termination, to verify if it falls under the right boxes that are provided for under the statutes. And then there is a question that I'm putting here is, it's difficult to, and this is a lot of the discussions on how the decision is made to terminate this position versus that other position. It's obviously a difficult choice to make, but we haven't had a specific example, but I just wanted to flag here the fact that if a decision is based on a ground that is discriminatory, then you might want to challenge that termination decision. If it's not based only on the interest of the organization, and if there is a suspicion that it's based on the fact that, for instance, the person is a woman or other discriminatory grounds, then I think it's important to be vigilant and to assess whether or not there is something that could be done on that aspect as well. Another point is on the fact that some of the organizations will be working on mobility. Is it possible to move that position in such and such region? Obviously, the adjustment cost might be cheaper for the organization as well, so there is also a budgetary issue. So this will be probably a solution that we will see a lot in the next month. Here again, there are some provisions in the different statutes on is there an indemnity, is there a repatriation grant, is there a notice period? Some of the organizations have very short notice periods for the relocation, so it's important to verify whether or not these notice periods have been used. And then again, I'm going back to that point that if there is a situation of harassment, of misconduct, it's obviously very difficult to raise that claim at this in this environment when you know that all the jobs are potentially at stake. But there are some mechanisms within the system that are meant to protect victims of harassment within the international organizations, and I think that it's important to still try to use these mechanisms. And maybe on that specific point, there are also some directives or provisions within the statutes that protect against retaliation. It's very theoretical, it's obviously much more difficult in practice, but somebody who files a claim should be protected against retaliation. So, how do we document, how do we strategize? First, when you have some doubts, when you want to, or in any situation actually, as earlier, keep written records. If you send an email to your supervisor because you have questions about this and that, keep that email. Don't keep confidential documents about the mission of the organization, but keep emails that are about yourself, about your employment situation. Seek legal advice early. Often the clients, they come to us after the fact, and it's not necessarily about going to private lawyers. You can go to the staff unions I was mentioning. There is the Office of Staff Legal Assistance for the UN employees. There are some private lawyers like ourselves. I don't know how much they would take on your questions, but for the permit situation, the Swiss mission might be also a resource person if you have questions about the legitimation cards. So seek legal advice early so that you don't arrive in a situation where you don't have the tools or you cannot really anticipate what the risks would be. Assess timelines. Because, as I said, the notice periods can be quite short in some instances. So, really, just maybe review the staff rules and regulations for your organizations, because you will have a clear idea on what are the notices that you can anticipate. Assess jurisdictional options as well, because one of the reasons why I'm saying that you might want to go early to seek legal advice is because some of the options are very limited in time. If you want to, for instance, file a claim before the ILO 80, it's 90 days. So it's 90 days. There wouldn't be any exception. And then I already mentioned it, but you have a protection against retaliation in those cases. So it's important to keep that in mind when you are too afraid to initiate a proactive step. Well, there shouldn't be any retaliation. Unfortunately, we see in practice that could be a problem, but there are some protections. I think that's this is very this is generic information. Obviously, for each organization, you have some specific points that are specific to the organization. But with this first panorama, we thought that it would give you some tools to know how to react if you were to be concerned with one of the measures that we have identified. The next part that will be presented by Emma is really specific to the permit situation and this career transition that might be also on the table if there is indeed a termination of the employment situation with one of the international organizations.
Yeah, so hi everyone and everyone listening from afar. So one of the biggest questions questions as well. When I have a carte de légitimation with my international organization, which is valid for the duration of employment, but when and if my job ends, how does it work? So first of all, I think it's important to know that you automatically receive 2 months courtesy period at the end of your contract. So your contract ends on the 30th of June and you have another 2 months to get ready and leave essentially, or get organized to obtain another job or permanent situation. So it's relatively short. In the current context, it is possible to ask your organization, to ask the Swiss mission to extend that courtesy period. For example, if you have children and your contract comes to an end in December, but you'd like them to stay in school for the rest of the school year, that might be a valid explanation for which you could present to your international organization, which needs to put the request to the Swiss mission for an extension of that courtesy period. So I think that's important to bear in mind as a first step. Again, retirement and early retirement, as Céline said, the people in the room, I don't know about the people at home, don't seem particularly concerned by this situation, but you have a 3-month courtesy period. And it's important to know that if you have adult children who have been in the country for more than 12 years, attached to your carte de légitimation, they can ask for a separate residency permit. And then the Swiss market situation is, or the Swiss permit situation is divided based on your nationality. So the Swiss job market is fully open to Swiss people. There is facilitated access for EU nationals and EFTA nationals, but that still requires an application, and it's more difficult for non-EU and EFTA nationals because they must and then got a carte de légitimation, they can request to retrieve, to get that permit back after their carte de légitimation ends. So that's an important element to keep in mind. EU and EFTA nationals can ask for a 12-month permit or a 364-day permit to seek employment. There's the option of a B permit, a C permit, and family reunification. I'll go over these various conditions. So the applicable law to the two categories is for EU and EFTA nationals, it's the Agreement on the Free Movement of People, ALCP. The law applicable to non-EU and EFTA nationals is the Federal Law on Foreigners and Integration, which from the 1st of January 2021 includes UK nationals because of Brexit. UK nationals who were employed before that date could have other options. There's an agreement on acquired rights for UK nationals. So if you are a UK national, I would look into those options as well. Also, asylum is an option if you cannot return to your country. So the first category of permits is the right to stay with employment. So for EU EFTA nationals, if you found a job, you announce, you fill in a couple of forms, announce your change of employment and job to the cantonal office. for population and migration, OCPM, and it's a pretty straightforward procedure. This also includes self-employment. You can be self-employed as an EU EFTA national if you're able to demonstrate that you have proven self-employed jobs. So in proven consultancies, it can take many forms. It can be proven payment for jobs, consultancy jobs that you've had. It can be future contracts. So I think that's a good option also for people who wish to stay and continue to work from Switzerland. For non-EU EFTA nationals, again, it's more complicated. You have to, the main principle essentially is that your presence in Switzerland must serve the economic interests of Switzerland. So what that means is that your future employer has to prove that they need you because you have specific qualifications, because you are more suited than any other EU national, EFTA national or Swiss national. And this is quite a heavy process. The employer needs to put the request to the Bureau for Employment and hope that there are sufficient quotas, sufficient positions, permits left, because there are quotas for the permits. There are 91B permits in Geneva and 146 L permits, so under 12 months permits. There is the possibility for the Canton of Geneva to then request to use some of the national quotas, but the numbers are quite tiny if we look at the number of people who work in international organizations. Additional requirements are that this salary that you're being offered is appropriate. It can't be far below an average salary that you could get working in Switzerland. It must be full-time employment. And finally, the request is approved by the State Secretariat for Migration. There is the possibility for those who are living in France and who've been commuting. So for non-EU EFTA nationals, you have to meet the same requirements. In addition to that, you must demonstrate that you have a permanent residence in France, and that you've been regularly residing in a neighboring border area for at least six months. And not all of the nearby areas in France are officially these neighboring border areas, which is confusing, but it's worth checking as well. So there's also the right to stay without employment. For EU EFTA nationals, you can get a B permit if you can prove that you have sufficient financial means and that you have health insurance, Swiss health insurance. But this also is applicable to those who might be employed by an NGO, for example, based in France or elsewhere, and you work from home. So if the center of your financial activity is not in Switzerland but elsewhere, but you would like to live in Switzerland, you can prove that you're receiving sufficient financial means and could apply for this type of permit. As I mentioned previously, there's also the L permit, which allows you to look for a job for up to 12 months. But again, you need to prove that you could live in Switzerland for that period of time, and that you are paying medical health insurance. For non-EU EFTA nationals, it's harder again. You have to have sufficient financial means. You're basically retiring. You've got the minimum retirement age, which is 55 years in Switzerland. Proof of personal links to Switzerland, perhaps family, perhaps property, could be anything. And you need to agree explicitly to not work in or outside of Switzerland. And then family reunification, which is also important in these situations. So I didn't mention spouses, but obviously family reunification applies to spouses as well, so it's married spouses. For EU EFTA nationals, you can also ask for family reunification for children up to 21 years old, as opposed to non-EU EFTA nationals, where you can only have under 18-year-olds come live with you. One interesting, perhaps tactical move, if say you've got a Uruguayan person who got a job in an international organization, and the family has followed that person, but their spouse perhaps has a European nationality, you could switch the person who allows you to stay grounded in Switzerland by having them apply for a job, get a B permit, and ask for family reunification through that spouse instead of the previous spouse. Also, if two non-EU nationals are applying together for a B permit, which is conditioned to these quotas, it's actually probably better to have one of those spouses apply for the permit, the better candidate, and use family reunification for the other spouse and the family for their right to stay. With family reunification, you have the right to work in Switzerland. And so kind of general steps, general recommendations. I mean, know your rights, know what situation you're in. If you think that it's not immediately, you might not lose your job immediately, or you might not want to change the situation immediately, but kind of along the line, I think because the deadlines is so short, 2 months, 3 months in some situations, or it's worth kind of knowing what your options are early on. And then when the situation arises, apply for a permit as soon as possible. Make sure that your dossier is as clean as possible, as well put together as possible, because when that is the case, the requests are expedited much quicker than if there are issues. The OCPM struggles a little bit when there is something that's a bit out of the ordinary. You have the possibility to sign up with the unemployment offices in Geneva, not necessarily to receive benefits, but you can receive guidance, help to reintegrate the job market. This is probably useful for those who are eligible for an L permit. Sign up for health insurance if you've applied for a permit, because the permit might take quite some time to be granted, and you don't want to be in the situation where you haven't signed up for health insurance when that is obligatory. So that was the slightly more technical and maybe less a bit drier part of our presentation, but I think we can open up for a Q&A now. Thank you for your attention.
So we have more than 30 people online. We had 34 at the max. So they have questions too, but please feel free.
I just wanted to refer to a slide, because there's a slide on liquidity.
Yes, this one.
It's and valid from not all, because we've conditions are cumulative.
Okay.
Second hyphen of the second point.
So it's you have to be Swiss, a Swiss national, or have a valid permit.
Yes, yes. I was thinking that it's others.
Sorry.
Drawing a remark. And then I really appreciated the discussion, the presentation. Just a small question about approaching those unions of staff employees. Because very often they don't have websites. And if we are in a recruitment situation, you have to be already in to get a contact onto that union. So the question is, how do you go about approaching those unions to ask questions about recruitment processes, no, but working conditions? And to what extent is it confidential? How do you manage the confidentiality aspect of this?
Yeah, I think we can go questions by questions right now. I'll answer that. It depends, I guess. Obviously, you know, when I mentioned the fact that you should be approaching the staff unions if you have questions about your situation as an international civil servant, I meant that it's probably that you're already in the organization. In which case, I think that you would have access to the staff union, and they would have also an interest in contacting you earlier in the process of you being employed. For recruitment, you know, I don't know, it would depend on the organization, it would depend on the associations, yeah, so I don't have a straight answer for that specifically. Plus, I'm not representing the staff unions. I really wanted to stress, though, that they have a key role to play if you have questions and you're already within the organization. But many people also come to us because they're not involved with the staff union and they would want to have an external advice from a private firm. So it's, you know, everyone has a different approach to the situation. Maybe,
yes, please.
All right, so I have some very brief questions here. The first is,
Sorry, could you speak slightly louder?
yeah.
can you hear me?
Yeah.
All right, so for statistics purpose, when did the job cost start? Is it with the current administration or it's been since 2024? Second question here is, how would you negotiate a situation where the job cut or loss is due by funding cut? And the third here is, in the US government, if you were employed less than 2 years, you were immediately terminated. So is that the same criteria here? You know, what was the criteria for termination? And then next question here is, let's say you're employed overseas, so you work remotely. How do you prove that to the Swiss government? What kind of documents do you need? And lastly, can a non-EU national purchase property? What's the process? Because I heard you talk about like purchasing properties and stuff like that. So
We'll divide.
yeah.
For the first couple of questions, the job cuts. You know, I'm not going to be giving a very accurate picture of the situation in terms of how many jobs and when, etc., etc. But what I can tell you is that the statutes, you know, even at the creation of these organizations, many of the rules, regulations, statutes, and regulations, they do have provisions on situations in which the organization has to terminate contracts. And the provisions are quite broad in some aspects. So, and my point was that if this situation arises, you need to look at what the rules are saying, and because it's not, you know, there is a framework, a legal framework. So it's important to look at that framework. The numbers. Again, you know, I've been like looking online to see how many numbers, and obviously we are following the discussions, but what we can anticipate is that there will be a wave of termination. There is already a wave of termination in some of the organizations in Geneva. So when that happens, make sure that the framework is being followed for your own situation. So, you know, I don't think I can answer like more specifically than that at this stage.
And I think you asked a question about how do you prove when you work abroad from a. Do you mean when you live in Switzerland, work from abroad? So, I mean.
And work for
a
business in a different
company
country.
which is abroad. Well, so I think one of the first elements is that usually that company would have to permit working from a different country, and if that's the case, then I don't really. You live wherever you want, but there are there are taxation issues or in retirement pension issues which the company probably has looked into, or the NGO or whatever. And in that case, if you're free to go, you can live from wherever. What I meant with the B permit, where you have that option to work from Switzerland, kind of at a distance, but for a company which is not based in Switzerland, then and you're not self-employed formally, you're fully employed by that company, then the center of economic interest is not in Switzerland, and therefore it would be for the Swiss immigration purposes considered a permit without employment.
But yeah, just maybe as a side note is that these situations are very specific and they have a very strong implication for our taxation. So, one would have to also look at the potentially the bilateral agreements between the two countries for taxations. There were many cases about that during the COVID period and the frontaliers, and so it's a sensitive issue. It's not that easy, but it's an option, and if one meets the criteria, then the person should know about that option.
Exactly. And about purchasing property, I mean, that's not an area that we particularly work in, and I'm not here to advise you to buy property in Switzerland. No, but that was just because some people have bought property and therefore can use that as a way to demonstrate that they have a particular link with Switzerland. It was in that respect that I was mentioning it.
So will they actually send you property in the first place? Because in the United States, you can come in as a visitor and buy property. That's never possible.
It's not that you would come as a visitor. It's that you will have lived here through what you can't. No, you can't as a visitor necessarily. I mean, I don't know exactly what the rules, honestly. But I mean, I think the situation that I was referring to specifically is, I don't know, I've been working for. I'm an international civil servant. I've lived here for 10 years. After some years, managed to buy a house, and now I'm being told you can no longer work in Geneva, but I have property in Geneva and would like to stay or retire here. So that's the situation.
Thank you so much.
Yeah, I just want to give the floor to people online. We have plenty of questions. So please, Carolina, Emric, and Leonard, maybe you can open your camera and ask your questions yourself. In the meantime, I will already ask Lisa's question, who cannot speak right now. Could you please advise on the rights and access to labor markets of someone who is non-Swiss, non-EU, but married to a Swiss with a Swiss minor child?
Yes, well, in that case, they could apply for family reunification.
Can you hear, Lisa? You can apply for family. Well, they are here, in fact.
Yes, but formally you would, for the permit, formally you would ask to receive a right to stay, a B permit, on the basis of family reunification. It's quite a bit easier when your husband or your spouse is a Swiss national. So that should not be a problem.
Are you okay with the answer? Caroline, maybe you can open your camera or at least your mic and ask your questions. Enrique's the same. Leonard, please go ahead. Yeah, Enrique, open your...
Yes,
You,
that's correct.
can you hear me?
So Lisa, yes, that's right. Yeah.
There's
And then Enrique,
information.
please go ahead.
Yes, my question was on the question of uh, localization. I was thinking job cuts are jobs are cut at the global level, but it is also the case at the Swiss scale. I mean, organization could be globally going to reduce staff, but we localize the staff in Swiss headquarters. Is it correctly to think like this or no?
I think
I mean,
we can't hear you very well, but I think
excuse me.
if it is, there's two options in what you meant, maybe you can clarify. If the headquarters of the international organizations are facing some job loss in Geneva as well, yes, they are. So we see that also here. And then the Swiss market for, let's say, private companies, we don't have much information on that, but what we can see is that at the canton level, there are some concerns on how all the persons who will want to stay in Switzerland will be able to find employment in the Swiss market. So I don't know if that answers your question, but the context is quite complex at this stage and uncertain. It's hard to have visibility on what will happen.
Leonard, would you like to ask your question? If it's not the case, I will do it for you. Did you see the question? Enrique's question. So it's my apologize. I'm thinking jobs in organization are cut at the global scale, but could they improve teams to keep projects going at Swiss scale? That was Enrique's second question.
I wouldn't know. You know, it's what happens within the internally within the organizations is something that we don't deal with. What we deal with is when somebody is faced with a situation of okay, I lost my job, or I got that letter, or they're telling me that I need to be relocated, or maybe the person wants to do what the organization is suggesting and relocate in another country. But us as lawyers advising international civil servants, we can also tell that person, look, here is the rule of relocation, here is what you could be doing, here is the grant that you are entitled to, here is what happens with your children, with your benefits, with your... So that's our perspective. But I see your point, it's just that I don't think we're the right interlocutors to get an answer to that specific question.
Is that okay, Enrique? For you? We can see you. So I have a question from Leonard, who is an incoming student. So he's planning to do his master here, but after hearing all this, he's reconsidering everything. And the question is, and you have Boule de Cristal, is the current crisis in international organizations likely to last the coming years? What can future prospect students expect?
That would be a question for the Graduate Institute, actually. Very famous researcher on the topic, and there were a series of conferences on that matter. My personal experience with the Graduate Institute was very positive, and I don't think one can know what will happen in the next future. So, I would still recommend to go ahead.
For sure.
Organizations are still hiring.
Of course.
There's a change in the situation. You saw the numbers, but I wouldn't be completely discouraged from doing a master's on the basis. Our perspective is very I mean, we've given information about permits because there are a certain number of people today who are facing those questions. And we've also, as Céline was giving you, kind of tools on how best to react in a kind of worst case scenario kind of situation. That's not the job market. That's not the whole picture.
And it's also, you know, depending on what you want to do with your career and what aspects of international law or international development you're interested in. This is also a very interesting moment in career as an international lawyer. We see the world changing, and we witness positions that we hadn't witnessed before. So it's also maybe the time for action, the time to change your practice towards something that might be more meaningful in that particular context. So I'm just being very philosophical here, but I don't think there is the right answer to that question. It really depends on your perspective.
Absolutely. Carolina, you have the mic and you have the camera, so please go on if you are ready. Sorry.
Yeah, I don't know if I can switch on my video, actually. It's not allowing me. But thank you very much for organising this excellent presentation. I just had a very specific question about the situation of British nationals who, obviously, after the Brexit, have lost their right to participate in the EU labour market. Those of us that were resident in Europe before Brexit, do we still count and have our rights protected? I don't know if you know about this, under Article 50 of the withdrawal agreement that was signed between the UK and the European Union at that time, I believe. Do we still have the right to be considered as EU nationals if we were resident in for example, France, and have a residency prior to Brexit, or are we considered nevertheless as third country nationals for purposes of applying for permits and being considered within these quotas that you described? Yeah. It's a very specific question, but that's my situation as I live in France. Right. I was resident here prior to Brexit, so I have a residency in France and I'm beneficiary of Article 50, but I don't know what that means in terms of my preference, like my rights to apply for work in Switzerland and how I would be treated in the Swiss system.
Well, so I know that Switzerland and the UK have a bilateral agreement on this issue for retaining acquired rights for British nationals in Switzerland, those who had the right to work or the right to live in Switzerland prior to 1st of January 2021.
Yeah.
I don't have the answer specifically to whether your status in France would then give you access to the job market and give you facilitated access to the job market.
Just to understand, you moved. You moved to France while you were under a legitimation card?
No, I've lived in Switzerland and I moved to France from Jordan when I found a job with the UN in Geneva. And I moved to France so that I would not lose all my rights under the European, under European law at that time. And so I became resident prior to Brexit, and I have now a permanent residency in France with this Article 50 protection. So as I understand, having asked the Swiss permanent mission, I can apply as a frontalier using this using my carte de séjour, titre de séjour français, séjour permanent French. I have to apply for a permis G once I find a job, if I need to find a job in Geneva or wherever in Switzerland. But my question is, am I treated under that regime when looking for a job as a third country national, or am I treated as an EU citizen, given that I have this article?
Yeah, it doesn't matter. I mean, but you mean for the quota of
yes, exactly. Am I one of these 90 or so people that might be employed as a third country national, or am I a European citizen?
Yeah, I think we don't have the answer to that
No, it's very
situation, unfortunately, because it would depend on French law or the EU law and the bilateral agreement in the UK, which I don't know.
Yeah. So you know there was a meeting recently with the Office of Migration and all the offices of the canton, UN, and that was, you know, the case of the UK citizens that had a permit, didn't have a permit, etc., is something that they also apparently struggle with. But so it's you're indeed in a very specific situation.
Yeah.
But,
because I mean, this would be exactly one of those. Sorry to interrupt you, but exactly one of those situations where, you know, the rights that we were actually entitled to pre-Brexit, I mean, would actually come into question. You know what I mean? That this is exactly the situation. So I know that it's very difficult. But
yeah, the overall, although, you know, there is an answer. Like we just don't have it right now with us. But the overall situation, though, or my impression on the position of the office is that if there is a possibility to retain previous rights, they wouldn't go against that. It's just we would need to look into the specific situation.
Yeah, so we're following up specifically then. Yeah.
Yeah.
Okay.
Thank you, Caroline. Thank you so much. So we'll have another round here because we still have plenty of questions here. So again, sorry. And then you and Malak.
So let's be very specific as well. When people apply to international organizations in general, they fill the form at the website of the international organization. Sometimes there's a voluntary disclosure, which sometimes has questions about whether you have children, what sexual orientation are you, whether you're white, black, what kind of background. It's for diversity purposes because organizations promote diversity, and it's marked clearly that this information will not be accessible to the recruitment team. But then once you're in, this information goes somewhere. The question is, from your experience, where this information goes in? Would you advise people to fill those forms, not fill those forms? Did you have clients or examples in which this came up during the termination of contract question when client had the doubt? Well, my contract was terminated, but I filled that form. So, what advice would you give clients in these situations?
Again, I think it depends on how the person wants to fill up the form. That goes back. It's what I was saying in my presentation. It goes back to the point on discrimination. Obviously, information about your personal situation are being disclosed within the organization. Just because you need to get benefits based on your personal situation, for instance, or you would get a legitimation card for your spouse or your children. So there are some health insurances also linked to your status as an employee. So there are some information about your personal situation that would be given to your employer. If the cases, full disclosure, at this stage, we haven't had a case of termination based on discrimination. We've had cases of career progression where the problem of discrimination was an issue. What we anticipate, though, is that there might be some questions of, let's say, indirect discrimination. For instance, if the lower level jobs are being cut and these lower level jobs are predominantly filled with women, then there is an issue. Like, should we be questioning that decision? But in terms of but in terms of career advancement or harassment, or the percentage of one gender within one team, for instance, this is something that we would look at in the case the person comes to consult us. But for recruitment purposes, honestly, I don't have a specific answer. It depends on the questions that are being asked. But the form is generic.
Yes, I have two questions. First of all, I'd like to know if there are any criteria which would allow for application for a B permit, but for self-employment for non-EU nationals? That's one question. And secondly, if the list of laws covering the situation of non-EU nationals was included asylum law, and I wanted to know what would be the procedure, or if there is a procedure for applying for asylum after having a causa de sumação, for example, if it were impossible to return to your country of origin.
So to answer your first question, no, the only way you could apply for a permit without, or you would need to demonstrate that your self-employment, or actually no, you would not be able to. You need an employer.
For non-EU,
it's really difficult. So you could set up a company, demonstrate that that company has, would hugely benefit the Swiss economy, and perhaps make it that way. I anticipate that you would need something really incredible to convince the Swiss authorities that would then that it's worth keeping you and your company here.
Maybe on that, because it's very much linked to the job market, and one position that we see and perceive from the canton and from what we see in the news is that there is a local interest in keeping highly qualified employees, and some of the international civil servants that have worked in the field of, for instance, human rights, like there is a huge level of qualifications, and so obviously there is the challenge of finding the job. But once the job is found, I don't think that the permit is still a challenge. But depending on the type of job, these qualifications are valued. So I'm trying to be a little bit more optimistic here, because it's not. This is a savoir-faire that wants to be kept, and that the authorities want to be able to keep in some ways. So obviously there needs to be an economic interest for Switzerland. That's one of the requirements. It's written in the law, but there is an economic interest in keeping valued qualifications such as the ones that have been acquired in the international organizations.
Yeah, we have alumni every year that will stay after their company and show this interest for Switzerland. It happens. It happens. Malak, the last question. Sorry.
Question. So the question was, what would the procedure be? What
Yes.
Well, so I imagine there are 5 grounds on which you can apply for asylum. You need to demonstrate that you have a fear of persecution if you go to a return country, that you fear for your life, or fear harm. And the procedure is unpleasant. I mean, you need to go to a federal centre and claim your asylum, and you will be asked or forced to stay in that centre for the duration of the processing of the asylum request. So it's not made to be easy. It's not made to be pleasant, and it can take quite a while, and yeah, you're given legal aid that's provided for, but yeah, it's a difficult process. I could go into more detail if you need it, but there is that requirement that you have to be in the country, and you have to physically go to one of these federal centres, of which there are 7, sorry.
Yeah. Before we wrap up, I just had 2 very short questions. Just to make sure that I understood properly, the quotas for non-EU is separate from the carte de need to Switzerland. It's like not okay. And then the bullet point regarding living in Switzerland while unemployed. So essentially, if I have, for instance, a B permit and I work here and I reside here, and my parents are above the age of 55, they can come and reside with me, or is that not strong enough proof of like ties to Switzerland for them to be able to reside in Switzerland with me?
Sorry. So, what nationality?
American.
Okay. So you don't have the right family for ascending the parents for family reunification. I mean, I think if you're an adult child, you cannot apply as a non-EU or EFTA national for your parents to come with.
It was more reversed.
Yeah.
The slide was reversed. It was for could you bring your children?
I meant it more so. There was a bullet point about like if you're unemployed, you can reside in Switzerland. If you're above 55, you have like proof of ties or like links to Switzerland.
Right.
So I guess my question is, like, would I qualify as a tie, as a strong enough tie for like parents or family to come and reside in Switzerland?
I mean, they evaluate it on a case-by-case basis. Sorry, I didn't understand your question. They evaluate it on a case-by-case basis. So a tie would, I mean, you could argue that that is a tie, but it depends kind of on how long you've been here, how attached you are,
what is your family situation?
What is your family situation? What is their family situation back home? It's a kind of global picture, and a tie in that type of context would be more personal to them in the sense that they've lived here for a long time. They have their kind of social spheres here, and so they're kind of claiming that, why should I leave Switzerland when I've invested, many years of my life in Switzerland? That situation would be a bit more complicated, I think.
Would it be better nowadays to be American or to be something different? From the East, or do you think there are better nationalities than others to be accepted? Officially, no,
all
but
countries which are outside of EU and EFTA are
at the same level.
At the same level. I don't think I can say anything more. I don't know.
Personally, I don't think so.
No, I mean,
No, just
No.
but the law is divided, non-EU, EU.
Okay. Well, then in terms of skills, maybe.
Well, so that's the thing. I mean, if it's your connection skills, access to facilitated access to the job, there is kind of difference in access, opportunity on that level. I think the Swiss authorities would look more favorably at a highly qualified American than a non-high or a kind of similarly high qualified person from a different country, but it's impossible to say for sure.
You think?
Really
Interesting. That's why.
Not sure.
Not sure.
Oh,
Do you have other
You cannot
questions?
quote me on that. We have no idea, but
No, but a feeling because you're.
What's the definition of highly qualified American?
highly qualified.
I heard you say highly qualified American.
Highly qualified American. I mean, so highly
qualified
qualified person is one of the requirements to access the non-EU EFTA job
Yeah, I
market.
don't understand that. I'm like, what's your definition?
Well, my definition is not particularly. I mean, it's the law's definition is somebody who's so highly qualified or skilled. So it can be a specific skill that is required by the job market. It can be higher education. It can be that you have met.
Master's degree.
But one of the points is it possible to find a Swiss employee to take that job?
Yeah.
So it's more tailored into that specific question than whether or not this is the level of education that you know, like for instance, in the US immigration laws, it's you have a H-1B if you have a bachelor's or plus. This is not, it's not designed in the same way, in Switzerland.
So it's, for a given job, can you find a Swiss person who could do that job just as well as the non-Swiss person? Then you will look at the broader pool. Can you find a European person who can do that job? And if you still can't find anyone within that pool, you can look outside of those categories.
Do you have other questions? If it's not the case,
Thank you.
Thank you.
maybe I'd like to close the event. Please stand up and let us know.
Okay. Well, thank you all for coming. For those of you who are still online, thank you for joining us. I'd like to take a quick minute to remind everyone, students, current and incoming, as well as any alumni that are joining us here today, that we are having our 12th alumni reunion, September 13th. So please join us. It'll be great. A great way to catch up with other alumni, to mingle, to chat, and for more information, check out our website. The event is up. You can get your tickets. Yes, thank you once again for sharing your insights. It was very, very helpful and very informative. So thank you. Have a nice day, everybody.
Thank you. Bye.
Bye.